just two quick questions. You sort of said this, I don't know if this makes sense. In general, what impresses you as a judge? Would you like to give us a little
organization?
Say about that? Okay, yeah.
Organization.
Organization. Mm-hmm.
If you've got your story organized, I'm always impressed.
Okay.
If you're focused on the issue you're there for, I'm always impressed. If you ask simple questions, I'm impressed. I have yet to run into a self-represented litigant who actually cross-examines well. So don't worry about that. Nobody does it well. There are lawyers who've been out 20 years who don't do it well. Mm-hmm. So don't concern yourself with the fact that you're, quote, messing up a cross-examination. Everybody does it. It's an art that has to be learned.
Right.
But I'm always impressed with people who are well organized and ready to tell the story in a focused way. You don't have to be, you don't have to be expensively dressed. People come in blue jeans and a sweater. If you're neat and clean, great. If you're not, because of circumstances, that's okay too. The small claims court is literally the front line of the justice system. It's there for everybody. It's not just there for rich people or people who can afford a lawyer or people who practice law. It's not like that. You come, and frankly, I haven't met anybody on our bench. There are about 300 and some odd deputy judges. I haven't met anybody on our bench who does not want to serve the public.
Amazing. That's wonderful.
All of the public, not just some of the public. Yeah. Right. So I won't be impressed by your clothes necessarily. I won't be impressed by, the kind of car you drive. All I want you to do is tell me what the issue is and what your side of the story is. And then I'll listen to the other side of the story and do my best to decide fairly. That's the job.
Is there anything you want to tell us about what you've seen at court that you would like not to see? So it goes to the part that what does not impress you.
I'll tell you what I don't like to see. And I say this to everybody at the beginning of every trial that I do.
Right.
We don't interrupt. We don't make faces. We don't make noises, dismissive noises, right? Two things. One, it's rude. You should know better. Two, it hurts your case, not theirs. Right? I won't be upset with them because you went when they gave an answer. Okay.
Right.
I will stop the trial and say, please don't do that.
Oh, okay. Right.
Please don't do that. I need to listen to the evidence.
Okay. Right?
I can't hear it if you are making noises or you're making faces and otherwise distracting me. I have to listen, right? So that does not impress me. Right. Jumping up and down, yelling at the other party does not impress me. Having to call security because you got into a fist fight in the hall with the other party does not impress me.
These things happened?
Every now and then.
Oh my gosh, okay.
Trials are difficult. People get, it's
that's true.
And I understand why and how it can happen.
Yeah.
I understand that.
Yeah.
But when you come to court for a trial, don't talk to the other side unless you have a representative and they have a representative and everybody can talk civilly, right?
Right.
Don't come expecting to persuade the other person that you're right. If you could do that, you wouldn't be at a trial. Right? You wouldn't be at court if he accepted or that person accepted that you were correct, right?
Yes.
The reason you're at court is that they don't. Those things don't impress me. I think probably I've had to call security maybe 3-4 times in 24 years.
Oh my gosh.
And one time the court monitor asked me not to decide the case right then.
Mm.
When we came out at the afternoon break, she said, at the end of the day, I'd be most happy if you reserved judgment because the parties are getting quite salty.
Oh.
Yeah. She said, I don't want a fist fight to break out in the courtroom.
Oh my
I said,
goodness.
oh, me either. You're right. I'll reserve judgment. Yeah. Every now and then it happens because they're emotional things, trials. That's the other reason we try to keep it so strictly structured.
Mm.
And we try to keep everybody using their church manners, right? Or using the manners you use when you visit your grandmother.
Okay, yeah. Right.
That kind of thing. And I do my best to imitate your grandmother because it's important that you stay cool, calm, and collected and let the process play out.
And be respectful.
Yes. Well, let the process play out and use your manners. Don't, we all know. I mean, every one of us knows that you're supposed to take turns.
Yes.
We all know that.
Yes.
Right? So
But it's really interesting because I think a lot of people, maybe because they're so emotionally vested that they see trials, they're thinking that trials are there as a battleground, I think. And so really, this is just to prevent them from actually taking their swords and pistol to the
That's
duel.
definitely the function of it.
Right.
That's definitely what it's a substitute for.
But
right?
they're still seeing it as a battleground rather than a civil way of resolving a dispute.
The key word is it's a substitute for the battleground, right? It's not the battleground because, and I often say this to people, look, the small claims court is there so that people don't solve their disputes with baseball bats.
Right.
Right? Yeah. We're there so that people can use their words, right? So people can come to court and have an impartial person decide what should happen next. Now, one person in the court is always going to be unhappy, right? Because somebody wins and somebody loses. That's why we have opportunities all the way along for people to settle, right? Because once you get to court, somebody you don't know, once you get to a trial, somebody you don't know me, I don't know you, right? Somebody you don't know is going to decide something that has an effect on your life.
Right.
So if you want to keep the control in your own hands, make genuine efforts at settlement. Because that way you'll keep the control.
100% agree.